for me to give advice on. Elevators, obviously they're part of the common property. Responsibility to maintain rests with the body corporate, as does building foundations. In your paper there, I've given some examples of a lot owner responsibility where the plan was developed by way of a building format plan, and we've spoken about most of those there. Number 5, I'll just draw your attention to exclusive use areas that the owner has the benefit of. Under the legislation, an owner must repair and maintain its exclusive use area. The legislation goes on to say that doesn't include a repair and maintenance obligation for foundation structures and the issues that we mentioned before. So if there's an exclusive use area and there's an issue under that area with the foundations, then unless the bylaw itself makes the owner responsible for those foundations, etc., then that's still going to be a body corporate responsibility. So if you get the opportunity to, or if someone is being granted exclusive use, and often the grant for these types of things, for example, a courtyard is made when the scheme's created, so you don't get an opportunity necessarily to draw the bylaw yourself. But if someone's getting granted exclusive use, then as a body corporate, you would want to make them responsible for that, for as much of that exclusive use area as you can. So it's very important to draft that bylaw so that it negates the provisions of the legislation, which still places responsibility on a body corporate for certain items with respect to exclusive use areas. Now, standard format plans are much simpler. As I said before, often if you have a picture in your head of a gated community, often with standard format plans, the only body corporate responsibility is going to be the roads through the scheme, perhaps a swimming pool, perhaps a tennis court. In the paper there, I've given you some examples of the body corporate responsibility. One thing that does come up is guttering. If the guttering services more than one lot, that's going to be a body corporate responsibility. Termites is often an issue that comes up with lots in a standard format plan. Whose responsibility is it for termites? The body corporate's responsibility is essentially with respect to its common property. So the body corporate should always, on a regular basis, make sure that the termite barrier is intact around the scheme. The owners are responsible for any pest control within the boundaries of their lot. A practical way to deal with the issue, although the guys at Capital will shoot me for saying this, is that when the body corporate does its termite control, at the same time it should offer a service to owners that the body corporate will manage the termite control for the owner. So it's all done at the scheme at the same time. The reason I said Capital will shoot me for saying that is because the way to do that under the law is by what's called a Section 169 agreement. They're sometimes unwieldy, they're a little impractical, and I don't know of too many bodies corporate that actually utilise them. So that said, you can deal with that situation with termites by those Section 169 agreements. The question that I'm often asked is, well, my lot in a standard format plan has been damaged by termites. Whose responsibility is it to repair the damage? That, of course, depends on, well, who caused the damage, and it seems to me that the critical question is, where did the termites come from? Now, if the termites travelled across the common property and caused the damage to a lot, then it's likely that the body corporate is going to be responsible to repair that damage. The problem with termites, of course, is I'm led to believe that they can have nests like up to 1.5 kilometres away from the scheme, for example. If the nest is found in the lot itself, then that lends itself to the likely conclusion that the lot owner is going to be responsible for repairing any damage caused by termites. So, like most things legal, whenever a question is asked, it really comes down to the particular facts at the particular given time to be able to give the body corporate the answer it's after. Now, the lot owner's responsibility with respect to lots in a standard format plan is pretty much everything. So everything within the boundary of the lot is going to be the lot owner's responsibility. One thing that comes up is painting of the lots. You've got, say, 50 little houses all standing alone within a gated community. How do you make sure that they're painted the same colour or similar colours so one person doesn't want to paint their house purple? How do you make sure they're painted at the same time? That's done, or can be done, through the community management statement, through what's called an architectural code. And you can place restrictions in that architectural code on colours. You can perhaps go as far as saying an item, a lot must be painted every 5 years, or as reasonably necessary. Painting, again, is an issue that comes up regularly with how is that funded. Because we're talking now about lots in a standard format plan, it is the owner's responsibility to fund the painting. They're responsible for paying for it. I've often seen in schemes where they issue levy notices, and there's the admin contribution, there's the sinking fund contribution, there's the insurance contribution. Down the bottom there's a painting contribution. So each quarter owners contribute a painting contribution, and then the body corporate goes and uses that money to paint the lots so that the owners don't have to, fork out $15,000, $20,000 in one lump sum. It's a fantastic idea, but it's totally illegal. There's nothing in the legislation which says that you can levy contributions on owners other than an admin levy, a sinking fund levy, and an insurance contribution. That said, it happens a lot, it works, and I'm all for it, and I'd be very happy if they changed the legislation to allow for it. The other way to deal with painting in standard format plans is to, again, utilise one of those Section 169 agreements whereby the body corporate engages the painter, and they have the body corporate then has an agreement with each individual owner that the owner will pay their contribution towards the ultimate cost of the painting. Now, the painters like it because then they only have to deal with one entity, the body corporate, as opposed to each owner. The thing I would encourage everybody to do, though, is if you go down that path of Section 169 agreements for painting, certainly what you want is the owners to make their contribution up front into, for example, a solicitor's trust account, so that you're not left, the body corporate's not left with having to chase an owner for their contribution, because the body corporate's got the contractual obligation with the painter, so the painter will come to the body corporate for payment. Body corporate's got to pay under the contract and then try and recover that money from the owner. So in my view, it's very important to have that money paid for into a trust account by the owner. Now, it's a little bit off topic, 5 minutes, a little bit off topic today. It's in the paper. It's a strict obligation to repair and maintain the scheme's common property, but you've still got to fund the repairs and maintenance. So when you're paying for these things, for those of you that are on committees, think about the spending limits, think about whether you've got to go to a general meeting to get authorisation to make the expenditure, think about whether it can be done at committee level, think about whether it's been budgeted for. If a particular item has not been in the budget and it needs repairing, then you're going to have to raise a special contribution, which, as we know, doesn't make people happy at all. Emergency expenditure: if something requires emergency repairs and it's beyond the committee expenditure limit, then you can do a couple of things. One is you can go to a general meeting and get authorisation. That doesn't really work because we're talking about emergency repairs when we're not going to wait 21 days. You can make a application to the Commissioner's office for an order that the committee expend monies above its limit to attend to the emergency repairs. And that was used extensively during the floods a couple of years ago. And the Commissioner is pretty quick to make orders, so they're quite cognizant of the fact that emergency repairs need doing, so they'll consider it quickly. The other thing that committees can do, although I certainly wouldn't recommend they do it, is they can make the expenditure and seek ratification at a general meeting from the owners to ratify the expenditure above the committee limit. The reason I don't recommend that is because you've always got the problem of, well, what happens if the owners don't ratify that expenditure? And there is a suggestion that in those circumstances the committees may be personally liable for the expenditure where it's not ratified. I want to leave time for questions, so just on the last page of my handout I have a brief discussion about the difference between improvements and repairs and maintenance. So when you're attending to things, you've got to make the decision or make the distinction between, are we improving the common property or are we repairing and maintaining the common property, because there's different rules for improvements to common property as opposed to repairs and maintenance. A very simple example is if you've got carpeted foyers and you want to replace those with tiles, for example, that's not repair and maintenance, that's an improvement to common property. There's been a decision that if you paint a building a different colour to what it was originally painted, that's an improvement to common property, not necessarily repairs and maintenance to common property. No, well that's right, so if you paint it purple it might not be an improvement. Neglect of common property. Throughout my presentation this morning I have peppered it with, it's a strict statutory duty to repair and maintain. A failure to repair and maintain a scheme's common property can expose the body corporate to a claim in damages. You might be aware of a case on the Gold Coast called Magog. I think it was the Moroccan and Magog. Magog owned a commercial lot in the Moroccan, and that commercial lot was leased by Prada. Prada obviously had very expensive items in the store. There was water leakage. Body corporate for 6 years did absolutely nothing about it, and there was various cases at various levels, but at the end of the day the court found that it was a body corporate strict liability to repair and maintain common property. Not only was the body corporate found liable for the repair costs, but they were also liable to pay the owner the lost rent because Prada ultimately moved out. And I think from memory the damages awarded against the body corporate were in excess of $500,000, and the body corporate had to raise, or don't quote me on this, but I think the body corporate had to raise a special contribution to pay those damages. Now, that's it from me. Any questions?
What's your address then?
Oh, my address now is 121 Logan Road. That's the easiest.